Welcome to the Office of Special Counsel's video series on prohibited personnel practices. Please be sure to visit our website at www.osc.gov to view the full series of videos. In this video, we will discuss the retaliation prohibitions. OSC is an independent watchdog agency. One of our core missions is to enforce and promote the goals of the Whistleblower Protection Enhancement Act. The purpose of the Act is to encourage agencies to foster an environment where federal employees may make protected whistleblower disclosures or engage in protected activities without the fear of suffering retaliation from their agency. The Act's provisions serve as a message to all federal employees that transparency and accountability are valued and will be safeguarded. So, how do the retaliation prohibitions work? To start, the Whistleblower Protection Enhancement Act prohibits retaliation against federal employees for making protected disclosures or engaging in protected activities. A protected disclosure is any communication that an employee makes where they reasonably believe that they are disclosing a violation of law, rule, or regulation, an abuse of authority, a gross waste of funds, gross mismanagement, a substantial and specific danger to public health or safety, or scientific censorship. A protected disclosure can be made formally or informally. It can be in writing or it can be verbal. It can be made on duty or off. The protections are meant to be broad. Beyond protected disclosures, the Act also protects certain activities. These are exercising any appeal, complaint, or grievance right, testifying for or otherwise lawfully assisting any person in the exercise of any appeal, complaint, or grievance right, cooperating with or disclosing information to an agency's inspector general or any other component responsible for review or internal investigation, cooperating with or disclosing information to the Special Counsel, that's us, or refusing to obey an order that would require a person to violate a law, rule, or regulation. If a federal employee believes that an agency retaliated because they made a protected disclosure or engaged in protected activity, the employee can file a complaint with the Office of Special Counsel.
When OSC receives a retaliation complaint, we examine the facts to ascertain whether there's an evidence of a violation. Namely, did the agency take, fail to take, or threaten to take a personnel action against an employee because they made a protected disclosure or because they engaged in a protected activity? A personnel action could be a firing, suspension, reprimand, reassignment, or any other action defined at Title V of the United States Code at Section 2302 B2A2. When an OSC investigation concludes that a violation occurred, we attempt to secure corrective action or relief for the whistleblower. OSC's objective is to ensure that the employee is made whole, as if they had never suffered the personnel action in the first place. Whether they're facing something as minor as a letter of reprimand or a reduced performance evaluation, all the way up to and including being fired from federal service, OSC attempts to return the employee's status and employment record to where they would have been in the absence of the retaliation. OSC can even seek corrective action in situations where the agency did not take a personnel action. For instance, not selecting a whistleblower for a promotion or failing to provide a whistleblower with a performance bonus. In addition to correcting a retaliatory personnel action or non-action, employees can also recover any reasonable out-of-pocket expenses that they can demonstrate were linked to the retaliation, such as attorney's fees, medical expenses, and emotional damages.
As a first step, OSC attempts to work with the employee's agency at the lowest level possible to undo the offending personnel action. If that initial outreach is unsuccessful, OSC may write a report to the head of the agency requesting that the agency direct the corrective action. If the agency still declines to make the employee whole, OSC can seek corrective action from the Merit Systems Protection Board, an administrative board that hears and decides federal employment cases. The employee alleged that he was terminated during his probationary period for making a disclosure to higher-level management that his supervisor was engaging in gross mismanagement and a violation of law, rule, or regulation, and for testifying in an internal management inquiry. OSC conducted an investigation, including requesting documents from the agency and interviewing witnesses and management officials with knowledge of the termination. The investigation concluded that there were reasonable grounds to believe that the termination was retaliatory because we established that the protected disclosure and protected activity were a factor in the termination, and the reasons cited in the termination were not supported by evidence. We negotiated a resolution with the agency to provide the employee with corrective action, including back pay, rescinding the termination, and $5,000 in compensatory damages. The complainant had already started a new job, so he did not request reinstatement.
Whistleblowers play a critical role in keeping the government transparent and accountable. Recognizing that role, whistleblower protections are meant to be broad. For example, the law does not limit to whom a disclosure can be made, as long as the information is not classified or otherwise illegal to disclose. There are no requirements for whistleblowers to make disclosures through their chain of command or to any designated person. Disclosures that would otherwise be unlawful, such as the disclosure of confidential taxpayer information, or disclosures that would reveal classified information, are still protected if they are made to OSC or to an agency's Office of Inspector General or other agency component responsible for review or internal investigation. The law protects whistleblowers even if what they disclosed turns out to be inaccurate, as long as the whistleblower had a reasonable basis to believe that they were disclosing, for example, a violation of law or gross mismanagement, then they are protected from retaliation. Here's the bottom line. The Whistleblower Protection Enhancement Act is designed to encourage federal agencies to provide an environment where employees feel safe and are safe to disclose wrongdoing or to pursue relief through protected channels. For more information about the prohibited personnel practices that cover retaliation, please access the other resources on our website.